luister na die OFM Sake Uur met Olebogeng Motse.
It's the OFM Business Hour, and it's powered by Standard Bank Business Banking. Olebogeng Motse is my name. On 19 May 2021, the Minister of Trade, Industry and Competition, Ibrahim Patel, released a statement on the competition policy for jobs and industrial development. Now, you may ask or be wondering, what is this policy about and how does it affect my business? Well, tonight, I'm speaking to Aidan Scallan from ENS Africa to speak on this very policy and answer those very questions as an expert in his field. He's also going to be pointing us to what we should be cognizant of with respect to this policy. Here's our chat. Aidan, well, tell us what the competition policy for jobs and industrial development is about and what does it aim to do?
So the competition policy for jobs and industrial development essentially sets out the Department of Trade, Industry and Competition. It sets out its competition policy, the DTIC's competition policy, and it explains how the DTIC's competition law aiding its broader policy objectives, but in particular in achieving various public interest goals in respect of merger regulation, but also market inquiries and investigations into potential anti-competitive conduct. I mean, I guess the main focus of the document is in relation to mergers, which is where the DTIC sees its biggest role being, and specifically the impact that mergers have on employment, broad-based ownership, supplier development and investments, as well as downstream benefication.
So before we get into the merger transactions and its impact or the impact the policy will have on that, my question is, does the policy have any bearing on the Competition Act and the role played by the Competition Commission / Tribunal, etc.?
So the policy document doesn't amend the Competition Act in any way, nor does it change the way the Competition Commission or the Competition Tribunal should interpret the Act, or at least it shouldn't change the way that they interpret the Act. What it does do, though, is it sets out how the DTIC views competition policy aiding its broader policy objectives. So, and I think this is why it matters, really, and this is the nub of it, is that the Competition Act makes provision for the minister to participate in merger proceedings. And we're seeing that more and more, I think, over the last sort of year or so. The minister and his team at the DTIC are participating in or indicating their willingness and intention to participate in more and more mergers and even, I guess, the non-high profile transactions. So historically, I think, you would expect if you were involved in let's say, the Walmart acquisition of Massmart from a few years ago, or more recently, the PepsiCo acquisition of Pioneer, there you would expect the DTIC to be playing an active role in a merger. But what we're seeing now is really sort of even in non-high profile transactions, the DTIC is participating or indicating their intention to participate, and through that participation, pushing these policy objectives. They are very focused on protecting employment, making sure that mergers don't result in any job losses. They also want to certainly make sure that a transaction doesn't reduce levels of broad-based ownership, but possibly also see improved levels of broad-based ownership. They are very focused on supplier development, so making sure that a merged business continues to use or even expands its use of South African suppliers, and they also want to see increased investment in the South African economy at all levels, but then also in particular in downstream benefication in the mining industry. And I guess this policy document sets out the DTIC's goals in relation to all of those things and explains some of the successes that it's had in the past in relation to these kinds of concerns and how it would like to see more of that happening in the future.
Well, what is the current status in SA pertaining to merger transactions, and how will the policy alter the situation?
The document doesn't necessarily change, or doesn't change the law in relation to mergers. And I don't actually think the policy marks any deviation from what we've seen historically. I think anybody that is sort of involved in mergers on a regular basis with the Commission would have seen the DTIC seeking to participate in more and more mergers. And I suppose what this document does is it really just codifies and provides a very helpful summary to competition law practitioners, but also business in terms of the topics or the agenda that the DTIC is likely to push. And I think what we're likely to see going forward, is a continuation of this increased participation. And I think this policy document signals the intention of the DTIC to play a much more active role in the regulation of mergers specifically, but also competition policy more generally going forward.
Tonight I'm speaking to Aidan Scallan from ENS Africa. You say in your statement that the policy document therefore highlights the need to take advantage of the Competition Authority's enhanced market inquiry powers to address the harmful effects of economic concentration. Can you elaborate further on those enhanced market inquiry powers? What are they specifically, and how can companies take advantage of them?
Market inquiries are a useful tool for the Competition Commission to assess the state of competition in a particular market and to potentially, where it identifies problems in that market, to proactively make interventions which will hopefully aid consumers. So I guess the enhanced powers don't actually provide anything for companies to take advantage of. It's really more the Competition Commission that now has increased powers in terms of the market inquiry provisions. And I suppose what those enhanced powers are, in 2019, the Competition Act was amended so that the Competition Commission now has the power to impose binding remedies on companies and an industry where they identify competition harm as a result of a market inquiry. Previously, after a market inquiry, the Commission could only make recommendations. So they have a lot more power, I guess, and more teeth to regulate markets than they did previously. I suppose at a procedural level, I think one of the other key amendments is that the Commission can now compel parties to provide information and documents using its powers of summons. Previously, in a market inquiry, the Commission could request information, but it was really up to a participant in that inquiry to determine, the level of information that it submitted in response to those questions. So yeah, I think just to summarize, the market inquiry provisions don't give really companies any avenue to leverage any sort of advantage, but it's the Competition Commission that has this power now, or these enhanced powers since 2019, and they can sort of use them to try and improve or to assess, and then if they find problems, improve competition in a market.
Mm-hmm. That's actually quite interesting. Now, the document notes that policymakers are considering the introduction of regulations to give effect to the national security obligations, and this is not yet in effect. What are your thoughts on that?
It's quite interesting. When the amendments were first announced in 2018, there was a lot of concerns raised around the sort of national security obligations and I suppose what you could call foreign investment protection legislation. What I think is interesting is that the proposed amendments, which, as you correctly point out, aren't in effect yet, the proposed amendments are not out of line with what you see in other countries. And so I don't think South Africa is out of sync at all with global trends in seeking to introduce such protections. Where the concern lies, though, is that the proposed amendments in their current form simply do not provide enough detail on how the process will work in practice. And I think as a result of that, I think there are genuine concerns that once implemented, if that detail isn't included, they could have the unintended consequence of stifling foreign direct investment in South Africa, because the parties would be unsure of what the regulatory process would involve, and also some of the, I guess, national security interests are very broadly defined in the proposed amendment, and it's not inconceivable that broad definition could be utilized to block transactions that really aren't problematic. So I think certainly we are waiting to see what additional detail is provided in relation to these amendments. And I think that's why, while a whole raft of amendments were introduced in 2019, these amendments didn't come into effect. And I think the reason for that is that I think there's been a recognition on the parts of government that there just isn't enough detail on this section yet. At present, the process is not going to work smoothly.
Aidan, any closing remarks or advice to industry players pertaining to this policy? What should they note, etc.?
I think, as I mentioned, overall, I don't see the policy document resulting in a seismic shift in the way the merger process is run. But I do think that the policy document makes the DTIC's intentions in relation to public interests clear. And businesses should therefore plan early in their transactions for how they're going to deal with these issues. They will be asked questions on them, and they'll need to give satisfactory responses. And if they don't do that, their merger process is likely to be a lot more bumpy and take a lot longer than it needs to, and potentially resulting in an unsatisfactory outcome for the parties involved. However, if parties plan accordingly and put in place measures that address these issues that are very important to the DTIC, I think they can expect their transactions to be approved far more speedily.
Great. Thank you so much, Aidan. Really do appreciate your time.
No, it's an absolute pleasure.
Some interesting advice there from Aidan Scallan from ENS Africa regarding the competition policy for jobs and industrial development. At the end there, he cautions businesses considering merger transactions to really be conscious of this policy, as not answering some of the questions adequately could stall or even delay a merger transaction. Now, to listen to this conversation, head on over to the OFM site. That's ofm.co.za. Click on read and then on business.
Jy luister na die OFM Sake Uur met Oliver Motse.